Hello, my name is Benjamin Rice. Welcome to your training on the Fair Information Practice Principles, or FIPPs. In this presentation, I'll give an overview of what FIPPs are. We'll take a look at each of the principles in a bit more depth, and we'll talk a bit about how FIPPs compare with privacy policies like GDPR and CCPA. Finally, we'll look at how the Department of Homeland Security puts the principles into practice. I'm hoping what you get from this presentation is some background on FIPPs, a greater understanding of its 8 principles, how FIPPs relate to current privacy policy discussion, and how they're used in practice. The Fair Information Practice Principles, or FIPPs, are practices regarding personal privacy that are based on recommendations made to the U.S. Department of Health, Education, and Welfare in 1973. Those recommendations were codified into the U.S. Privacy Act of 1974. The Organization for Economic Cooperation and Development, OECD, expanded on these principles and published them as a guideline in 1980. Today, they serve as a foundation in privacy legislation like the General Data Protection Regulation, GDPR, and California Consumer Privacy Act, CCPA. The OECD published 8 principles that I'll go over in more detail now. The collection limitation principle, as written by the OECD, says that collection of personal data should be limited to lawful and fair means, and that the subject of the data should at least have knowledge of the collection and give their consent as appropriate. The data quality principle states that the personal data collected should be accurate and complete, and that the collector should keep this data up to date. In practice, this has meant giving the data subject some mechanism to view the data an organization has and to correct it as necessary. The purpose specification principle states that the agency should specifically state the purpose of the collection, use, and maintenance of the data to be collected prior to its collection. Further, it states that any change in purpose also be specified. And the use limitation principle guides the conduct of collectors after the personal data has been collected. It works hand in hand with the purpose specification principle, limiting use of collected data to the purpose specified except with the express consent of the data subject or by the authority of law, including the disclosure of information to other parties. The exceptions in this principle have proven difficult to interpret within the principle, and possible use has been difficult to foresee. The security safeguards principle states that the agency should maintain security safeguards of the data against unauthorized use, modification, including destruction, or disclosure through administrative, technical, and physical means. These safeguards should be commensurate with the harm that could result in the unauthorized use, modification, or disclosure of the data. The openness principle, sometimes referred to as the transparency principle, is rather general in nature, stating that there should be an attitude of openness behind the policies and practices involved with the collection and use of personal data. With this principle in mind, we can say, for example, that we should default to disclosing to the subject that we are collecting the data, seek their consent, and allow easy access to address any discrepancies, unless there is a very good reason not to. The individual participation principle states that the data subject should have a right to participate in the use of their data. The collecting organization should have a means to affirm or deny whether they have data on an individual and allow that individual to see and maintain it to the extent possible. If an organization has good reason to deny such a request from an individual, the person should be given that reason and a means to challenge it. Going back to the openness principle, an agency should seek the participation of the data subject to the extent allowed, as opposed to keeping things hidden until an individual makes such a request. And the accountability principle puts the onus on the organization collecting and using the data for adhering to the other guiding principles. It also is on the collecting agency to audit the correctness and integrity of that data and regularly audit their policies and procedures regarding personal data to ensure they maintain compliance. The FIPPs principles are not legal requirements in and of themselves. They were written as guidelines on how governments, specifically the US government, should craft its privacy legislation, and in fact, with several of the practices already identified serving as the basis for the US's Privacy Act of 1974 prior to the OECD's publication. After that publication, the Council of Europe passed a treaty called the Convention for the Protection of Individuals with Regard to Automatic Processing of Personal Data, or ETS 108. The treaty allowed for the flow of personal data between countries so long as certain privacy principles were maintained, and the FIPPs were the basis for these principles. ETS 108 paved the way for the privacy legislation we see now, like the EU's General Data Protection Regulation, GDPR. In GDPR, we see a strong influence of the FIPPs principles of individual participation, purpose specification, and limitation uses. Individuals have a right to be informed that data is being collected and why. They have a right to access that information and rectify it, and they have a right to opt out of collection. Under the GDPR, EU citizens also have a right not only to opt out of data use, but to specifically opt out of automated processing. One other note about the GDPR is that citizens have a right to data portability, something not mentioned in FIPPs. An EU citizen can not only request data on themselves from a data controller, but request it in a transferable format that can be then transferred to another data controller. FIPPs also provides the backbone of the principles of the California Consumer Privacy Act, CCPA. It contains limitations on collection and use to specified purposes, incorporates the individual participation principle, much like GDPR, in giving subjects the right to see their data and rectify it. It also includes elements of the security safeguards principle and accountability principle on putting the onus on the data controller and specifying fines if portions of the act are not adhered to. Finally, it implements the openness or transparency principle by instructing data controllers on how they should publicize and update their adherence. Let's look now at how one particular U.S. government agency, the Department of Homeland Security, DHS, has implemented these practices. DHS notes under the transparency principle, which I've referred to as the openness principle, that they make direct notice of how information collected will be used on the forms that are being used to collect it. They inform people, specifically travelers, on data collection and use through signage, and they publish privacy impact assessments and system of record notices publicly, including on their website, dhs.gov. Under individual participation, the department says they try to work directly with the data subject whenever possible, and that redress actions are available through the Freedom of Information Act and Privacy Act. The department went further to implement a program they call TRIP to specifically address issues that travelers have. The PIAs and SORNs are the main vehicles for DHS to address purpose specification. Additionally, the department says there must be proper legal authority and purpose attached to each data collection effort. Data minimization is akin to collection limitation. The department says they work under the Paperwork Reduction Act to reduce data collection and focus especially on not collecting Social Security numbers where they aren't needed, recognizing some inherent vulnerabilities in using SSNs as a unique personal identifier. Use limitation is also addressed through the PIAs and SORNs. The department does state that personal data may only be used by employees on a need-to-know basis, and the department routinely reviews, quote, routine use of private information. Data quality and integrity may be addressed through the Freedom of Information Act and the Privacy Act and TRIP, as stated in the individual participation principle. The department works directly with the Office of Chief Information Officer and Chief Information Security Officer of the U.S. to implement data security. They relate they have a specific sensitive systems security policy and that their data systems must adhere to and systems undergo a private threshold analysis on a routine basis. The department is under oversight by the Chief Privacy Officer, Inspector General, General Accounting Office, and Congress. Having worked on data security projects within the federal government, albeit in another department, I know that accountability does not stop at the auditing of logs, but that the government uses real-time data analysis and monitoring, and regular publications are done to keep systems as up-to-date as possible. In summary, we have discussed FIPPs, what it is and how it came about, each of the 8 principles in some more detail, how FIPPs compare with and are used within current privacy guidelines, and how the Department of Homeland Security implements these principles. Thank you.